Well, thank you very much indeed, Mr. Dowden. It's a pleasure to serve under your chairship. I'll first of all respond to the comments that the Minister made on the illegal working penalties and then move on to the second instrument relating to rental. Labour supports the principle of prohibiting those with no legal right to be in the UK from undertaking paid employment here. Indeed, it was a Labour government that enacted legislation in 2006 which first established civil penalties for employers who failed to comply with these restrictions. For these restrictions to have teeth, civil penalties must be set at a level which is onerous enough to deter employers from knowingly and deliberately breaking the law. With that goal in mind, it is right that the maximum fines for employers should be kept under review and, where necessary, increased. That said, I'm sure the government doesn't want to impose burdensome regulations on small businesses just for the sake of it. That can be avoided easily enough, provided the government consults with employers on the potential impacts of any changes and takes action to mitigate any undue burdens or unintended consequences for the businesses affected. Not for the first time, the Home Office has fallen short of what might reasonably have been expected of it. In the explanatory memorandum, the only reference to any consultation with employers is in a terse paragraph, confirming that none has taken place. Given the magnitude of the proposed changes, a tripling of penalties from £15,000 to £45,000 per worker for first offences, the failure to consult is surprising and disappointing. The party that the Minister represents claims to be a pro-business party, and yet it appears they haven't consulted with business on this important change. So if the Minister perhaps could explain why there hasn't been a consultation with business, I'm sure that members would be happy to hear that explanation. More broadly, this order represents a missed opportunity on the government's part to set out a clear, comprehensive and effective strategy to combat illegal working across the board, including the use of the civil penalties scheme. The failure of ministers to do so is all the more disappointing in view of the fact that such a review has been promised by the Home Office following a recommendation made back in 2019, Mr. Dowd, by the Independent Chief Inspector of Borders and Immigration, but appears to have gone the way of most recommendations that are accepted, quote-unquote, by the department, which is to say they get put in a drawer and forgotten about. Perhaps my cynicism is unjustified, in which the Minister is more than welcome to correct me and tell me exactly when the fabled strategy on illegal working will be published. Just as is the case with the other SI we will be discussing shortly, there is a risk that these higher fines feel like another case of the government running out of ideas and just making things that are already illegal a bit more illegal.
Will you give way?
I will give way.
I'm sure I will agree that tackling this problem would be an awful lot easier if the Conservatives, Liberal Democrats and SNP hadn't ganged up to defeat our plans for identity cards when we were in government. Every other European Union country has them. Absolutely no reason at all why we shouldn't, and that's why they're facing these humongous problems.
I thank my honourable friend for that excellent intervention. The debate around identity cards is one that's been raging, one could say, for a very long time, and I think it's certainly something that needs to be looked at very seriously. But as he knows, the whole project got knocked, kiboshed, I should say, yes, off at the time, in the time that he refers to, and I do think that it's something that merits further discussion. Turning now to the right to rent checks with civil penalties for non-compliance. So these are a means of supporting the objective of tackling and deterring illegal migration. On that basis, the argument goes, the higher the penalties imposed on landlords for letting to migrants who are in the UK illegally, the stronger the deterrent against further unlawful migration. Given how emphatically the government draws a direct link between these higher penalties and tackling illegal migration, members might have expected ministers to put forward stronger evidence to support the policy and support that link, and yet they have not done so. Again, it feels rather like the government running out of ideas and resorting to making illegal things more illegal. It feels fairly unlikely that channel crossings would be deterred if only immigrants could see that it would be hard to rent a home on arrival in the UK. Now, if there are genuine pieces of evidence to support the effectiveness of these penalties in the context of deterring irregular migration, again, I'm sure members would be very grateful to the Minister if he could please point those out. But let's say, for the sake of argument, that penalties on landlords do serve a purpose as a deterrent. The question the government then has to answer is whether there could be any unintended consequences of the proposed increase, and if so, what steps will be taken to mitigate any harm to those who are here perfectly legally. I'm sure the Minister's aware, although I don't think he mentioned it in his comments, but apologies if he did, I may have missed it, that there is evidence which shows that lawful residents, including British nationals, have faced significant barriers to securing accommodation as a result of landlords' fears of being penalised for even unintended breaches of the right to rent requirements. In fact, evidence published by his own department shows this. As early as 2014, when the scheme was first piloted, research showed that landlords, out of an abundance of caution, reacted to the new rules by favouring would-be tenants who were white, who could produce a UK passport on request, and even in 27% of cases did not have, and I quote, foreign-sounding accents or names. As was all too common with the old hostile environment policies, there seemed to be at least as much of a burden placed on lawful migrants and British-born citizens as the unlawful migrants the policy is supposed to target. The problem is not that the Home Office wasn't aware of this evidence, the problem is they simply dismissed it. In doing so, Ministers said that clear guidance to landlords was available in case of any doubts as to what they are or are not required to do. So I wonder if the Minister's view is that the guidance is sufficiently clear and, more importantly, made known to landlords so that any risk of unintended discriminatory consequences had been minimised as far as practically possible. To be clear, we on these benches are not saying that the right to rent system is inherently unworkable or unacceptable, but it is incumbent on ministers to set out what specific steps the government will take, both to mitigate any adverse effects on lawful migrants and citizens, and to ensure that any evidence of discrimination that is brought to ministers' attention is swiftly acted upon with appropriate remedies and safeguards. And I look forward to hearing a clear commitment to that effect from the Minister here today. Thank you, Mr. Dowd.